I want to reiterate what Marge had brought up as to how radical the Citizens United decision is. You know, the organization, Citizens United, that brought this whole court case forward, never even asked for this type of decision. This isn't what they were going for. They were just challenging a small provision within the McCain-Feingold law to try to exempt themselves to allow some corporate money in their in advertising their movie called Hillary the Movie. They assumed Hillary Clinton was going to get the Democratic nomination back then. They were wrong, but that's irrelevant. They never even asked for this. What happened was, before George Bush left, he was able to appoint 2 new justices to the Supreme Court, Alito and Roberts. And these justices are not just conservative. I mean, the Supreme Court has never really been much of a liberal institution, you know, but these justices are extremely corporate-oriented. And with those 2 new justices, it gave the very conservative members of the court a 5-4 majority. And what happened is, they heard the Citizens United case, and then announced that instead of ruling on what Citizens United is asking us about, we want to go back and take a look at 100 years of jurisprudence, perhaps going as far back to the 1907 Tilden Act, and judge whether or not the ban on corporate financing of elections is constitutional. So they took a little case and turned it into a major case challenging a century's worth of political tradition here in the United States. And we know how they ended up ruling. Shortly there, by the way, they gave all parties involved in the case, including Public Citizen, who was working on it, just 30 days to rewrite the brief and address a century's worth of legal tradition. And, you know, they weren't interested in the briefs, obviously. So they ruled shortly thereafter, January 21st, 2010, that corporations are to be treated as persons under the First Amendment, and therefore can make unlimited campaign expenditures. Now, Justice Kennedy, who wrote the majority opinion, first of all, Justice Stevens, who wrote the minority opinion, just wrote a blistering attack on the 5 justices, you know, basically, you know, saying this is absurd to treat corporations as people under the First Amendment. But Justice Kennedy, who wrote the majority opinion, you know, tried justifying their new decision. You know, he wrote that, I understand this is probably going to bring in a lot more money into politics. But don't worry, because with the McCain-Feingold law, we now have a very good sweeping disclosure system. So we're all going to know where that money's coming from. And so don't worry. This is quite a naive Supreme Court, which I will show you shortly here. First of all, to get to the numbers, I do want to emphasize that Citizens United has been so destructive to our electoral process in more ways than one. One is obviously the numbers. What we saw is immediately following the Citizens United decision, 2010 is the last red bar, we saw a 427% increase in outside spending over the previous non-presidential election cycle in 2006. You know, typically, spending in a non-presidential, just in congressional campaigns, is always much, much lower than the presidential campaign. And in 2008, we had a record-breaking presidential campaign. Well, the 2010 congressional elections just about matched everything that was spent in 2008 congressional and presidential races combined. I mean, literally more than a 4-fold increase. And the impact it had, I mean, where did a lot of this money come from? We have a good clue here when we take a look at corporate donations in federal elections. I want to emphasize this chart is a very incomplete chart because we really don't know what happened in 2010, which I'll get to a little later. But prior to the McCain-Feingold law, which took effect in 2004, corporations were basically laundering money, corporate money, into campaigns through the guise of soft money. This was something the Federal Election Commission deemed would be appropriate, even though it really was not allowed under the law. But the FEC said soft money is okay. Soft money would be corporate and union money that's used for coalition building or mobilizing voters, but not actually for advertising. Well, most of this money actually was being used for advertising, which was the whole point of the McCain-Feingold law. No one knew exactly what a campaign ad is versus an issue ad. We have been operating for decades off the Buckley distinction, where the Supreme Court wrote in a single footnote in that decision that the way you distinguish a campaign ad from an issue ad is if it uses one of the magic words, vote for, vote against, elect, then it's a campaign ad. If it doesn't use those magic words, it's an issue ad. Well, as a result, what was going on was this corporate money, as we documented, was being used to pay for ads equivalent to this one, for instance, during 2004, where Al Gore was being targeted as, voting for raises in gas taxes at the pump. Don't be gored at the pump, is how this happened. And it aired right before the 2000 presidential election. Never said vote for or vote against. That's where corporate money was being used. The McCain-Feingold law stopped all that. It went into effect in 2004, zero corporate money flowing into our elections. 2006, it was still in effect, zero corporate money really flowing into our elections. Now, corporate money was going through back doors to try to pay for some literature or other things, but it was not buying television ads, and it was not buying radio ads anymore. The McCain-Feingold law achieved exactly what it intended to do. Then our new Supreme Court, in 2007, began whittling away at the tenets of the McCain-Feingold law and ruled that corporations can pay for some campaign ads as long as the campaign ad also has an issue focus. So right away in 2008, we saw a significant increase in corporate money flowing back into the elections. And then following the Citizens United decision in 2010, all we can document right now is a rise of $138 million in corporate money, but this is not the whole picture. Most of the corporate money goes entirely undisclosed. Literally, the real picture would be double that line and off the charts, as what happened in 2010. But we've been able to document corporate money where it is disclosed and where it's disclosed to these super PAC entities. And there we see the $138 million, but it was much higher. We know $300 million was spent by outside groups in the 2010 elections, more than fourfold increase over previous cycles. We know where that money came from, even if we can't document it. And who are the groups that pay for this? Literally half of all that new spending came from 10 groups. Half of all this new spending came from 10 groups. Leading the pack, of course, is the U.S. Chamber of Commerce. This is the group that is fighting the disclosure requirements tooth and nail. American Crossroads PAC, I don't want you to be misled here. Karl Rove set up two different groups called American Crossroads. His first one was a legitimate, regular PAC that files with the Federal Election Commission and discloses their money. Then he realized that he can get a whole lot more money if he sets up another group called Crossroads GPS that doesn't disclose anything, and then he can get all the corporate money, the corporations that don't want to be out in the limelight, and pull in their money. So Rove really has two groups going on here, American Crossroads and Crossroads GPS, that if you put them together, they actually outspend the Chamber of Commerce. All but three of the top groups refuse to disclose where their money is coming from. Overall, this is the collapse of the disclosure system. With the McCain-Feingold law in effect, in 2004 and 2006, we had near 100% disclosure. All these groups were disclosing where their money came from that they're using for campaign ads. Following that 2007 Supreme Court decision, the FEC loosened the disclosure rule, and we immediately saw it collapse to about 50% disclosure. Then as we entered 2010, it fell all the way down to 34%. So all that new money that has been flowing into our elections, we only know where about a third of it's coming from. We literally don't know where 2/3 of that money is coming from. And I want to emphasize, the FEC has really put out the green lights. Don McGann, one of the Republican commissioners of the FEC, has essentially let everybody know that they are only going to require disclosure if a donor actually earmarks when the money is supposed to be used for which ad, in which state, at which time. Which no one does that. No donor does that. I mean, the donor gives the congressman money for the congressman to choose how he wants to spend the money, how he thinks he can use it best. You know, we don't sit there and earmark which campaign ad it's going to be used for. As a result, all these new corporate donors realize that they don't have to really reveal the fact that they're giving money, as long as they funnel it through the Chamber of Commerce or some other group like that. As a result, 2012 is going to be a disaster. I mean, we saw a 427% increase of mostly secret corporate slush money in 2010, just months following the Citizens United decision. Those 10 groups that were set up there, most of them, several of them, were just brand new groups that just materialized right after the Supreme Court decision. They were testing the waters. They were just, 2010 was just a trial. You know, they wanted to influence the congressional elections, but what they really want is to get the White House in 2012. And so we are going to see an unbelievable amount of spending and secret spending coming up in the 2012 elections. Well, following the Citizens United decision, I set up an emergency congressional briefing, and the room was overflowing, and I didn't even have any bagels or coffee. And it was just staffers who were really concerned about how they can do their job. One staffer actually asked me, how do I say no to a deep-pocketed corporate lobbyist, knowing that that lobbyist can orchestrate a multi-million-dollar campaign against my boss if I don't comply? How do I say no to a lobbyist? Now, this is the fallout of Citizens United when it comes to the legislative process, and it's exceedingly serious. You know, we have to revisit this, because what's going on is when the Supreme Court said corporations can spend unlimited money, it's not corporations spending that money. It's the CEO of the corporation dipping into the corporate treasury without telling anybody, including the board of directors or shareholders, that he or she is going to take that money and spend it on elections. You know, so it's just a CEO who is suddenly spending other people's money. So I thought simple corporate governance, you just require CEOs to inform shareholders. But I've yet to be able to get a single Republican to sign on to that legislation.